What's going on, guys? It's the Bad Wolf, the man in black. But today I think, well, we're going to do blue and even a little red. So this particular video is going to be about the use of a warrant in arrest. Now, if this is your first time watching my channel or video, please be so kind to hit that bell like and subscribe. Thank you in advance. As always, guys, if you see anybody using any of my materials inappropriately, make sure that you guys go ahead and report them for defamation of character and all that other good jazz. Otherwise, if you do need a consultation or questions answered, you can hit up BlackSite32 and find me on social media platforms and also discounts, programs, and things to help you out. I guarantee if you go there, you will find something that will help you out on your normal day-to-day basis. Trust me. I'm dedicated to helping you guys out because these are things that have already worked for me, and these are your rights and freedoms with the Constitution of the United States of America, Bill of Rights, Declaration, Constitution, all that good jazz right there for you guys. Got some hot for that ad. Anyway, all right, so we're going to start off with that section. There are other ones. I'm going to have one that's going to have the full information, all of it in the video. Right now, we're breaking them up into segments just so that people who just want that key piece, I guess I could have just kind of done the whole thing and then tagged each section. Now that I'm halfway through it, we're just going to finish it up this way. Because some people have told me they like the shorter things. Said no girl ever. Well, there was this one girl. She was weird. It was about she liked Asian guys. So no offense to Asian guys. I'm just saying that was her words, not mine. But and then I'm gonna have the longer segment. But if you guys want the file itself, you can go to BlackSite32. It's on there, or do a random Google search for the file, and you will be able to find it. That way you can read through it on your own and cross-reference it and whatever else. Because also in here, it does have the Supreme Court cases, district court cases, where this was already made law. They've already ruled on these things. You guys most of you have never heard of this. So once again, this also is information that goes out there to help law enforcement and to those who've reached out to me in a positive manner. I appreciate you guys and your hard work. It is a lot to know and do. And hopefully some of this information can help you guys and help all of us as Americans. And anytime somebody is against, well, just to keep it honest, the Constitution, me helping to spread awareness about the Constitution and your rights and laws, you are a traitor. You're a traitor to this country. And I don't like you and my America. And all the good American people out there coming for you. And by that, I mean in a non-belligerent, non-combatant way. Okay? Because we will not allow our rights to be trampled on. Let us not forget the flag that says, "Don't tread on me. My rights will not be infringed." With that being said, guys, let's get into it. All right. Lovely assistant, take it away. So we're starting off with the use of a warrant in arrests.
39.6. The use of a warrant in arrests. The requirement for warrants in the seizure 0, persons and property is an affirmation of common law principles. The declaration in our constitutions prescribing the mode in which may are to issue reflects the abhorrence of the esse of the so-called general warrants, whereby easy and arbitrary arrests and seizures are made. Despite such declarations for the security of liberty, privacy and property, history shows that the executive department has strong tendencies to disregard and violate them, as revealed by the U.S. Supreme Court. Though the police are honest and their aims were RTHY, history shows they are not appropriate guardians of the privacy which the Fourth Amendment protects. While the Fourth Amendment has been badly violated, we find that the due process of law provision is virtually ignored when it comes to warrants. For the most part, it is the due process provision which prescribes the actual requirement of a warrant for all arrests except where public security allows a warrantless arrest. Warrant to be in the possession of the arresting officer. A warrant of arrest is a written order issued by a court or magistrate, directed to a peace officer or to a specified private person, commanding him to arrest a named person. 2. It is regaride as fundamental law that where one cannot arrest without a warrant must. Jones vs. United States, 362 U.S. 257, 273, 1959. Be acquired and be in the actual possession of the one making the arrest, otherwise he is not protected by it. The requirement of having the warrant for arrest in actual possession is the common law rule and thus is part of due process of law, as it is a procedure which deprives a citizen of his liberty. In a case where a policeman, by direction of a sheriff, arrested an individual pursuant to a warrant, it was claimed the arrest was unlawful since the sheriff retained the possession of the warrant in his office. The Supreme Court of North Carolina held that the overwhelming weight of authority for misdemeanor charges is that the officer must have the warrant in his possession. The court stated the
Now, there's some more information behind this that we will be teaching in the seminars coming up. Right now, it's VIP only, but we will be having it open to everybody. It's going to be on a first come, first served basis. We will be doing them from month to month. So you'll have to pop back to blacksite32.com to see when they're available. As I make more videos, I will let you guys know that they're coming up in advance. So right now, if you do go there, you're just going to see that there's one or two for VIP, but we will be opening them up. And once again, these will be first come, first serve, and they will be open to the first 100 people. If we start getting more than that, I will then open it possibly up to more. For us, it's not really about doing like a ton of numbers, but just keeping it to a manageable amount of people and maintaining the quality of the information. So some of them will be live, some of them might be recordings, pre-recorded that you guys can watch. We may eventually make it so that, you know, instead of having to attend a live one, that you guys can just go ahead and download for a reduced price the videos after the fact. So that is an option. We're still trying to figure out what's the best way to do all of this. This is all still yet new for me. People have been requesting this information and to do seminars since day one, and all this is a lot to put together with just me and my skeleton crew. But yeah, we're getting there, guys. We got you covered. So let's keep it moving.
stated the following in 6 CLS, Arrest, Section 4, page 576 etc. We find the general rule stated as follows. The warrant must at the time of arrest be in the possession of and with the person purporting to act thereunder or of one with whom he is acting in conjunction. Accordingly, where the warrant is at the officer's house some distance from the scene of the arrest, or in the hands of another who is not at the scene of arrest, or in the central office of a city Detective Bureau, the arrest is unlawful. 3. Since there was no felony or breach of peace committed in the presence of the policeman, his arrest was deemed illegal despite the fact there was a valid warrant for the individual arrested, since it was with the 2 Wharton's Crimina. Procedure, Volume 1, 121H edition, Section 54, page 151. 3 Alexan.derv. Lin.say, 230 NC 663, 55S.E.2D 470, 474, 1949. 40. Sheriff who was in another town. The court also said that the good faith of he policeman did not affect the unlawfulness of the arrest. A Mississippi case involved a warrant that was issued for the arrest of a Bill Smith on a reckless driving charge. Under the sheriff's instructions, a deputy went to Smith's home to arrest him while the warrant remained in the sheriff's office. Smith asked to see the warrant for his arrest. The deputy replied that he did not have it with him, but that it was at the sheriff's office and Smith could see it when they arrived there. However, Smith said he would have to see the warrant before he would submit to the arrest. Smith resisted the arrest. The sheriff was called out but came without the warrant. Smith again resisted but was forcibly taken to jail. The state Supreme Court held the arrest unlawful, Under the great weight of authority, an officer making an arrest for a misdemeanor not committed in his presence must have the warrant for such arrest in his actual possession if the arrest is to be lawful. In a criminal case involving a violation of a lien, a policeman was given a warrant for the arrest of a man named Shaw. He drove to Shaw's house in a buggy. He left the warrant in the buggy, being some 150 yards from the house. The officer went into the house and put his hand on Shaw's shoulder and told him that he had a warrant for him and to consider himself under arrest. Shaw asked, "What for?" The officer replied, "For disposing of property under lien, and that a Mr. Bradham had sworn out the warrant." Shaw said, "I am not going." He resisted the arrest and claimed at trial that the arrest was not valid, as at the time of arrest the officer had not actual possession of the warrant. The state Supreme Court held that the warrant was in fact in the officer's possession. The authorities agree that in cases of misdemeanor not committed in his presence, and for which he cannot lawfully arrest without a warrant, the officer should have the warrant in his actual possession at the time of making the arrest. It was not necessary that he should have the warrant in his hand or in his pocket at the time of making the arrest. Actual possession of it does not mean that the rule is satisfied if the officer has such possession of the warrant that he can produce it with reasonable promptness on demand. Point 1. The question of what constitutes possession of the warrant has often been debated, but it is obvious that it must be so close at hand as to show it upon request. Thus it need not be said that the warrant must in all cases be directly in the hand of the arresting officer. This would be too narrow and technical view of the law, and one not based on substantial grounds. One reason for actual possession is to show the authority for the arrest, another is to display or read the warrant, and since this is to be done promptly, the possession must exist. Thus the warrant must be in possession but not necessarily in hand, as the Federal Circuit Court of Appeals stated. He officer who seeks to arrest by virtue of a warrant must have the warrant in his possession at the time of the arrest. We need not undertake to define exactly what is meant by in his possession. Of course, it does not necessarily mean that the warrant shall be actually in his hand. 6. Where a warrant was directed to all police officers, and exhibited to 2 officers but was kept in the police station, the warrant. For Smil vs. Ciale. 208 So.2d 746, 747, Mississippi, 1968. Although an officer upon seeing a misdemeanor being committed cannot arrest the person committing it, he can in most cases stop him from committing it or prevent its continuance. Thus in observing a petty theft, an officer can stop the suspect, which would be an arrest, to recover the items taken. 5. Stain. Shaw, 104 SC 359, 89 SC 322, 323, 1916. Is not sufficiently in the possession of the officers to sustain an arrest by them. In the rather famous and landmark case of Crosswhite v. Barnes, a warrant for the arrest vs. Barnes was issued by a justice for a N.S. demeanor and placed in the hands of T. Crosswhite, chief of police. Crosswhite, along with a police sergeant, set J1 Q execute the warrant, but left the warrant of arrest in his desk at the count house. When the officers first saw Mrs. Barnes, she was driving down State Street in her automobile. The police turned their car in front of Mrs. Sarn's car to stop her. One officer opened her car door, took hold of her by the arm, and said, "Get in my car." She refused and told the police she would not go any here without her husband. The policeman said, "We want you, not your husband." She asked the officers to show her the warrant. Mr. Crosswhite said he did not have to do so, and said that you are going low the courthouse.
Violation.
The argument continued, ending in Mrs. Barnes being forcibly taken to the courthouse. Mrs. Barnes brought an action against Crosswhite and the other policeman for illegal arrest and assault and battery.
false
The
imprisonment,
police were found
trafficking.
guilty, and on appeal, the Supreme Court of Appeals of Virginia affirmed the conviction, and in a very authoritative decision stated, "The textbooks generally state, and many cases hold, that it is necessary not only that a warrant of arrest should have been issued, but that the officer making the arrest shall have it with him and show it on request."
Yep. Take
In
that.
Beale's CRIMPI and Pro Section 18, it is said, an officer arresting on a warrant must have the warrant with him and must show it on request. 41. In 1 Bish. New CRIM Proc. Section 190, it is said, to justify an arrest under a warrant, the officer must have it in possession, and, if though delivered to him, he leaves it at his office or station house, it will not protect H. 1M. In 2 RCL, Ruling Case Law, 465, Section 23, speaking of misdemeanors not committed in the presence of the officer, it is said, the officer should bave the warrant in his actual possession in order to justify the arrest, and if he docs not have it, although it has been duly issued, an officer making an arrest may not be protected by it. 8. The court also referred to and relied upon a previous case in Virginia, the case of Musco v. Commonwealth, in which a policeman undertook to arrest Musco for a past misdemeanor, without a warrant, and Musco shot and killed him. He was convicted of murder, and in the appeal the court reversed the conviction, stating, "Indeed, not only must there be a warrant in the class of cases last mentioned, misdemeanors but, to justify the arrest, the officer must have the warrant with him at the time." 9. Since a warrant must be in one's possession to arrest, a sheriff has no authority to send a deputy to one place to make an arrest without a warrant, while he goes to another for the same purpose with the warrant. Nor can be sent his deputy into one town while he gives pursuit in another. 10. Under the ancient practice of hue and cry, before warrants were issued, this might be done in the pursuit of felons, but no hue and cry could be raised for a misdemeanor. 6. Coloran 42. We think it clear that in cases of misdemeanors the sheriff must be present either in sight or hearing, directing the arrest, to justify a person not armed with the warrant to make the arrest. In a Georgia case, a warrant was issued for the arrest of Shaw, charging him with a misdemeanor. The warrant was directed to any sheriff, deputy, coroner, or constable of the state. When a constable tried to arrest Shaw at his home, a friend named Adams interposed and asked the constable if he had a warrant for Shaw. The officer replied that he had it at his home, but not with him. Adams thus prevented the arrest of Shaw and liberated him from the custody of the constable.
Now, mind you, before you guys get a little too cocky out there, it only stopped him in the moment because he didn't have it with him. But once it has been obtained or secured and properly presented, okay, now, once again, there's some more aspects to even that warrant itself that we're going to talk about in the seminars, okay? So that's why you're going to want to look for those. But in general, this is what gets your feet wet, okay? This is going to help a lot of people out here just in general. But if you want to look at the quantum syntax and minutia of even the warrant itself, there's more to it, okay? But in general, this does stop them in the moment. But if they want to secure one, or if they already have it and they bring it and you ask and they present it, it may be prima facie good, meaning on first glance, but there might be some imperfections that can void that. But in general, keep in mind that when they go and get it, they can legitimately then arrest you, legally and lawfully. All right. So let's get ready to rumble, or just back to the document at hand. Hit it.
Constable Adams was charged with interfering with the arrest. The Supreme Court of Georgia held that Adams was not guilty of any offense since Shaw was not legally in the custody of the officer by virtue of a lawful arrest. The constable had no authority to arrest except under the warrant which he did not have in his possession. The court held, whenever a warrant has been issued to arrest a person charged with an offense in respect of which he cannot be apprehended without a warrant, the police officer must have the warrant in his possession at the time when he executes it. If he has not, the arrest will be illegal. Later, the court upheld this case under a similar situation, where a warrant had actually been issued for an arrest, but the warrant was in the hands of the sheriff a number of miles away from where the arrest took place.
Violation.
The arrest was not lawful as the officer making the arrest had not been in possession of the warrant. 13. In many cases, unlawful arrests have occurred where an officer receives some sort of communication from another jurisdiction or a central office that a warrant exists for the arrest of a particular individual. The officer relying on such information and making an arrest upon it is liable for false imprisonment, as be arrested without a warrant in his possession. 1 TREATISE says, in a case where the officer of any city, county or district telephones to officers of another city, county or district to make an arrest of a party with the last mentioned city, county or district, it affords the officer attempting to carry out the instruction no protection and the arrest is illegal, unless such officer would have a right to arrest without a warrant. 14. Thus, where an officer was informed by a letter, written by the chief of police of a city in another state, that a certain person BAS absconded with funds belonging to a benevolent association, the officer was liable in damages for the arrest of this person without a warrant. The fact that a person knows that a warrant for his arrest is outstanding does not eliminate the need for possession of the warrant in making the arrest. In Anderson's Treatise on Sheriffs, it states, where arrest is being made under the authority of a warrant, the officer attempting to execute same, and arrest the party named therein, must be in possession of SAID warrant or it affords him no protection. The necessity for the possession of the warrant is not relaxed by reason of the fact that the AR to be arrested knows of. 2 Kralserv. Malt W.S., 233 Michigan 452, 206 NW 982984, 1926, citing, Topple 2. Mealtal, 68 Michigan 480, 36 NW 231. 12 Adamal vs. Ciale, 121 GA 163, 48 esse 910, 911, 1904. 13 Gittels Lot. Slat, 154 GA 54, 114 Wa Iter H. Anderson, the issuance and existence of such warrant for his arrest. 16. Thus, where an arrest is made without tu ving, he warrant in the possession of the arresting officer, such an arrest is treated as lug it were made without a warrant. Warrant to be shown upon arrest, coupled with the requirement to have the errant in possession when making an arrest, is the requirement to show or display the / art to the arrested person. Where an arrest is claimed to be made under the authority of a warrant, it is the duty of the one making the arrest to show the warrant and read it to the one being arrested, especially when he requires to see it or demands to know the nature and cause of the arrest. He need not submit if this is not done. In the case of Smith versus Stair,
Did you hear that? You have the right to request, not even just request, demand to know the nature and the cause of the arrest. And by the law, he needs not submit if this is not done. Now, I'm not telling you to necessarily go out there and fight by any means, because, hey, at the end of the day, if they're doing something wrong, as much as I hate to say this, comply. Unless they're doing something in a sexual nature or immoral or whatever else, then fight. But in general, if it's legitimate enough in the moment, though they're breaking your rights and laws, cooperate because survive the day, the moment, the encounter to win the battle later. Okay, let's go on.
Supra, the Supreme Court of Mississippi not only said that the warrant must be in the actual possession of the officer, but he must show it to the accused, if requested to do so. 7 in Stale v. Shaw, Supra, the court said that the reason that a warrant is to be in the actual possession of the arresting officer is that, if demanded, he must produce the warrant and read it to the accused, that he may know by what authority and for what cause he is deprived of his liberty, /8. In Crosswhite v. Barnes, Supra, it was slated that the arresting officer must have the warrant with him, and must show it on 43. Request. It cited a number of authorities in support of this, such as the following. In the annotator's summary of a note in 42 LRA at page 682, it is said, an accused person, if he demands it, is entitled to be warrant for his arrest shown to him at the time of arrest. See also 51 LRA 211.19. In an early case in New York, a special deputy was charged with the duty to serve a warrant for larceny, issued by a justice of the peace. The person arrested required the deputy to show him the warrant before he would submit to the arrest. The deputy did not do so and the man resisted and the deputy beat him. At trial, the judge charged the jury that if the defendant did not show the warrant to the man, he was a trespasser. The jury found a verdict in favor of the man arrested. The Supreme Court of New York upheld the verdict, stating, a special deputy is bound to show his warrant if requested to do so, and if he omit, the party against who the warrant is may resist an arrest. And the warrant under are such circumstances is no protection against an action for an assault, battery and false imprisonment. Point 10. Failure to show or display a warrant. When a warrant for an arrest allegedly exists, the arrest becomes illegal. On this matter, the Supreme Court of Georgia stated, in Galfiard v. Laxalon, 2 Best and S. 363, 9 Cox CC 127, it was held that in a case in which a lawful arrest could not be made except under a warrant, the arresting officers were bound to have the warrant ready to be produced if required, that an arrest in such a case by police officers who did not have the warrant in their possession at the time was illegal. 21. 16 Walter H. Enperson a TREATISE all la y sheriffs, coroners and COLIS labels, Volume 1, Section 133, page 128, 1941. 17 Smith I. State, 208 So.2d 746, 747, Miss, 1968. 18 State I. Shaw, 104 SC 359, 89 SC 322, 1916. 19 Crosswhite v. Barnes, 139 VA. 471. 124 SE 242. 245, 1924. 20 Frizzle v. Thomas, 24 Wendell's Republic, New York, 418, 419, 1840. 21 Adams v. State, 121 GA 163. 48 SE 910. 911, 1904. 44. Thus the primary reason for the officer to have the warrant in his possession when making an arrest under the warrant is so that it can be shown to the one arrested, so that he knows the authority by which he is being deprived of his liberty. This was so held by the Supreme Court of Texas. It ought not to be denied that the law contemplates that the warrant directing the arrest of a person charged with a crime will be in the possession of the officer when he makes an arrest under it, for he is required to exhibit it, if called upon to do so. And this is based on a wise public policy, one purpose of which is that the officer may have to exhibit such evidence of his authority to make the arrest as will be deemed sufficient to take from the person whose arrest is commanded all right to question the authority of the officer. Point 2z. The argument that officers are free to arrest because there is a warrant outstanding is nullified by the requirement of law that one arresting under a warrant must show it if requested to do so, which is manifestly impossible unless he has the warrant in his possession.
Whoa, huge gem drop there, gentlemen and ladies. Visor down, going in. Highway to the danger zone. All right, all right, all right. So what did they say? The argument that the officers are free to arrest because there is a warrant outstanding is nullified by the requirement of law. Your law, their law, the law. That one arresting under a warrant must show it if required to do so, which means you can request that. And if they don't have it, suck an egg, which is manifestly impossible unless he has the warrant in his possession. So, gem drop. When they took your kids for child protective services, did they have a warrant? And if they did, what type of warrant? Because there's a warrant on the state level, which is a bench warrant. There's an Article 3 warrant. Gem drop. There's ways to deal with that. But in general, if they took you or deprive you of your constitutionally protected rights by God, they have to have a warrant in hand in that moment. Now, they can just take you if you don't object or ask for the warrant. But if they don't have a warrant on hand right there, it doesn't matter. If the computer says they have a warrant, they need it in hand. Gem motherfucking drop, people. Come on, you hear me? Are you hearing me? Do you understand what it means when these people have asked me to join them? Asked me to join them. Because since I was 19, I've been beating them across the board. Put that in your pipe and smoke it. They were so impressed that they wanted me to join them. It's because I get it. Now, I don't know all of the law. I don't know every single passage. And I wish I could afford the Americans jurisprudence and all of the secundum law books and everything out there. You know, I only have well, I guess I have a decent amount of materials. I am not the god of law. I'm not claiming to be the godfather, other than maybe a right to travel. That's kind of my baby, and the passport, along with Colonel Von Wilson, of course. But I've been doing this a long time, and just because other people want to be like, oh, well, you didn't create it. No, I didn't create none of this. I might have created some processes that can be used, but none of them are actually really needed. Everything was already here. I'm just making it look good, making it palatable, understandable, overstandable for the average person. That's the ticket. Oh, and I am a nice person and I treat people respectively. I respect you, but if you give me a reason not to, then I won't. But I give you that courtesy out of the gate. What you do with it is on you. So I digress. Once again, the arresting officer must have the warrant upon request. Let's go.
Possession. An officer arresting for taxes due on a tax warrant was held to be a trespasser where he had not the warrant with him at the time of arrest, thus failing to show it.
Woo! And let me tell you something. Well, you know what? This is more for the seminars, but arresting you on a debt. I don't know. The UCC says stuff about that. But anyway, I digress. Better have the warrant in hand. And all I can say is that if you've been arrested on an IRS or any other tax debt, let's just say the law is on your side if you know how to execute it. I'll give you that.
It to the one arrested. The court unanimously held. We think the authorities asterisk are all to he effect that the officer making the arrest must be in a situation to show, if required, the authority under which he is acting. It is the legal right of the citizen when arrested that such shall be the situation, and, therefore, when such situation does not exist, the arrest is a legal wrong. 23. 22 Cabelv. Arnold, 86 Texas 102, 23 SW 645, 646, 1893. An arrest warrant is to be shown to the accused, for he has a right to see if it is a valid warrant. Speaking on the topic, production of warrant, one law textbook states, every person relying upon a warrant in making an arrest should read it if requested so to do, where a warrant is necessary, but the person making the arrest refuses to exhibit it when called upon to do so, he may forfeit the protection which it otherwise would afford him. 24 In the Annotation of American Law Reports, Volume 40, page 62, a review was given on the topic, necessity of showing warrant upon making arrest under warrant. The report clearly showed many other cases that held that the officer must show the warrant upon request, and stated, the weight of authority now, however, seems to support the proposition that an officer making an arrest under a warrant should show the warrant, if requested to do so, and in some jurisdictions he is expressly required by statute to do so. 25. The enactment of a statute that the warrant is to be shown upon arrest is but declaratory of the due process procedure that must be followed in an arrest. Thus no statute is needed, and where it exists it is merely redundant in nature. The annotated report did speak of some authorities where it appeared that the failure of showing the warrant was allowed. It stated in the review that in some cases, a regular officer does not need to show his warrant before making an arrest thereunder. Such cases involved the question of whether the officer is known or unknown to the person. 23 Smith v. Clark, 53 NLL 197, 21 Atlanta 491, 1891. Citing Webby. Slate, 51 N.L. Law 189, 17 Atlanta Republic 113. 24-2 Ruling Case Law, Arrest, Section 23, pages 465-66. 2540 American Law Repons, annotated, page 66, numerous cases cited. Arrested. In some cases it was stated that the officer is known he need not show the juris tb/ or the arrest, but must show it and to be arrest. And where the officer is known he is to show the warrant before to be just. Other cases where it appeared that the ring of the warrant was not needed is ere resistance is offered or threatened, for the person asked to see the warrant. The argument that a known officer need display his warrant at all, or that in lieu of displaying it need only state the authority which he is acting, is not justified by AE principles for why warrants are needed in J.E. first place. Such an argument could completely take away most of the safeguards of liberty which the requirement for a warrant as established. The true law on the matter requires the officer to possess and display the errant whether be is known or not, and in addition to his stating the nature and cause for be arrest. The generally recognized rule, however, sustained by the weight of authority and particularly in cases of misdemeanors, requires the officer to exhibit the warrant of arrest before the arrest is made, unless there is some resistance. 26. In an English case cited in 40 ALR, annotated, it was held that where a constable making an arrest did not have the warrant, him, he was not justified in making the arrest. The court said, we have already expressed our opinion that, if requested, the officers are bound to produce the warrant, and, if so, the keeping in custody after request and non-compliance would not be legal, and it can hardly be contended that the arrest itself could be legal. J.21.
So what they're saying here is that they cannot, upon your request, now if you agree to go with them, it's all good in the hood. But if you say, well, yeah, show me the warrant, they have a legal and lawful duty, requirement, in order to make anything else from that point on valid, point of interest to do such as you have requested. So once you've requested it, they then also cannot hold you there, means you are free to go until they produce it. Now, some of them may overstep their authority and try to give you a direction or an order to which you say, are you asking me or are you ordering me? That's all they can do. And if they're ordering you, you're not a soldier nor a member of their ranks to be ordered. And if they're asking you, well, then I politely decline. If they're going to do it the legit way that they're going to order you, then they have to have the warrant there in place, which means the proper judge and everything must be in compliance with said warrant, warrant in their hand at the time thereof. So they cannot keep you there and say, oh, well, I don't have it right now, but I'm just going to run back and get it. You sit tight right here till I come back with it. It's not how it works. Not how it works at all. Not even a little bit. Let's get back to it, shall we?
21. 45. In an older English case, it was said that the doctrine that an officer need not show his warrant was a dangerous doctrine. The court also stated, I do not think that a person is to take it for granted that another who says he has a warrant against him, without producing it, speaks truth. It is very important that, in all cases where an arrest is made by virtue of a warrant, the warrant, if demanded, at least, should be produced. 28. The reason for the duty of an officer arresting a party by virtue of a warrant was declared in Commission v. Cooley, 6 Gray, Massachusetts, 350, 1856, as being to explain the cause for which he makes the arrest, to state the nature and substance of the process which gives him the authority which he professes to exercise, and, if it is demanded of him, to produce and exhibit it to his prisoner for his perusal, that he may have no excuse for resistance. The court added that these are obviously successive steps, which cannot all occur at the same instant of time. In a New York case, a man was convicted for resisting a police officer who attempted to arrest him for a past misdemeanor, the warrant being at his office. His conviction was reversed because it was the duty of the officer, at the time of the arrest, to disclose to the defendant his authority and the process under which he was to be arrested.
Now, this doesn't mean that I agree that whatever this guy had done, he shouldn't have been arrested. I don't know what he did. And in this particular scenario, I really don't care because I don't have any evidence to, and it's not my place to really pass judgment. But the officer didn't follow the law. The law is absolute. T's crossed, I's dotted. And if you fail at any one point in it, it has not been perfected, which means they are in violation, which is why his conviction was then overturned. There's going to always be some exceptions to these things where, the bad guy does get away, unfortunately. And this may or may not be that scenario, but that is why the officers need to not only ensure that they do things properly with the bad guys, but also not go out and harass and deprive the good guys of their constitutional rights. Just saying. All right, let's jump back in it. Hopefully everybody's doing good out there. You guys still with me? Awesome. Let's go.
Arrested. The court said the state statute was the same as the common law doctrine on this matter. If the officer must show the warrant, if required, then it is plain that it must be in his actual possession. It would be absurd to construe this to mean that after making the arrest the officer must, if required, take the 26 Walter H. and 46 defendant to some other place and there show him the warrant. Warrant. 29. It is clear that the warrant must at the time of arrest be shown, not at a later time. In Stair v. Finney, 42 Me 384, 1856, the Court, in discussing authorities, stated that it is very important in all cases where an arrest has been made by virtue of a warrant, that the warrant should be produced if demanded. In Shovlin v. Calm, 106 Pascals, 369, 5 a.m. Crim. Republic 41, 1884, the Court, in explaining the duty of one making an arrest, said, "It is doubtless the duty of an officer who executes a warrant of arrest to state the nature and substance of the process which gives him THC authority he professes to exercise, and, if it is demanded, to exhibit his warrant, that the party arrested may have no excuse for resistance." In Jails v. State, 114 Ga 79, 39 C 861, 1901, the State Supreme Court held that a constable was not justified in attempting to arrest the defendant under a warrant which was in to be sheriff's hands. The court said that it was the duty of an officer who attempts to make an RSLLO exhibit the warrant if has one. Invalid and unlawful warrants. A warrant must have certain requisites in order to render it valid and available as a defense. Many unlawful arrests have been made due to warrants' failure to meet such requisites. Whenever a warrant is invalid on its face, or where it is only a summons, the officer arresting the defendants will be liable in 29 Op/V Shanley, 40 Hun 477. 478, N.Y, 1886. Damages. 0. A prima facie invalid warrant will be regarded as no warrant and the officer making an arrest by a void or invalid warrant is not protected by it. Process that is void on its face is no protection to the officer who executes it. If a warrant, order, or writ of possession shows lack of jurisdiction of the court, the officer is not protected in serving it. In fact, in so doing he becomes a trespasser. 1. A constable justifying an imprisonment under a warrant must show that the warrant on its face is legal, and that the magistrate had jurisdiction of the subject matter. Why both a proper subject matter jurisdiction and geographical jurisdiction are necessary for a valid warrant. It is generally held that where the court has no jurisdiction, the officer executing a warrant will be liable in damages. The question of jurisdiction can be raised at any time. And since neither consent nor waiver can give jurisdiction, the court will not proceed where it appears from the record that it has no authority. 33. A warrant for the arrest of an alleged fugitive was void because the complaint did not state that the original charge has been made upon oath or made to a court, and it afforded no protection to the constable. 34. The requirements of what a warrant should contain depends primarily on constitutional mandates, due process practices, and common law principles. The common law requires that an arrest made OD a warrant be issued only after a formal 3051 L.R.A. 19 Dorge is made under oath. 5. Thus no arrest is, unless based upon a sworn affidavit. Affidavit.
So now you're learning that not only do you have to have a warrant, but in order for it to really be valid, you need a sworn affidavit. Now you are beginning to see, my young Jedis and Jedises, or whatever. I think it's just Jedi for men and women, whatever. And who has the ability to make a sworn affidavit? Gem drop. Gem drop. somebody living.
Affidavit. An affidavit that does not appear to have been sworn before any judicial officer, and a warrant signed only by the officer who made the arrest and not dated or authenticated, afford no lawful authority for the arrest and detention of an accused. 36.
There's a lot of points that were just made in there. Like I said, some of which we're going to go over in the seminars. Yeah, you got to know this information.
36. Another obvious requirement of a warrant would make it void on its face is if it is not signed by a magistrate or justice of the peace. It become a practice in some areas to have RNTS rubber stamped with the judge's name. This stamping being done by some clerk or administrative employee. This blatantly unlawful practice has been adopted for convenience sake, which is the most common reason or excuse government uses to transcend constitutional limitations. Such limitations /IORA designed to make government follow certain established procedures and thus make things difficult in order to deprive a citizen of his liberty or property. A rubber-stamped warrant is invalid on its face as it is not signed by any judicial officer.
Did you hear that? Gem drop. This is definitely one of the pieces that we will be talking about and is the exact piece that we will have in the seminars given to you here and now. Gem drop. A stamped warrant is invalid. Period. Now, when you start learning this, you start putting all this together, you start understanding that even if something in the past has occurred, and you go back and get your old warrant, and it was rubber stamped, it was invalid. You can have your cases overturned. Ooh, that's huge right there. And then you can sue them for those things in the district court. Ooh, Wolf, making it hot. Hot in the city. Hot in the city tonight. But let's keep going. We got more pieces.
The authorization for a warrant requires not only judicial authority but is to be done by one who is learned in the law to detain if probable cause exists to issue the warrant. In Minnesota, the state Supreme Court held that a statute permitting clerks and deputies clerks of the county municipal court to receive complaints and issue warrants in 35 MO of Slate, 140 Nebraska 592. 47. Prosecutions under municipal ordinances is unconstitutional. The court said, the United States Supreme Court has considered and disposed.
Did you hear that? Prosecutions under municipal ordinances. Municipal sounds all big and scary. It basically means a entity which is not living, first of all, hint, 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 who has their own corporate ordinances for corporate people, corporate legal persons. It's unconstitutional.
Disposed of a rela TCD problem in Camara versus Municipal Court, 387 U.S. 523. 541. The majority in Camara nevertheless stressed the need for individualized review by a neutral magistrate to avoid the issuance of rubber stamp warrants. 17. Since the taking of an affidavit in a criminal proceeding imposes a duty of a judicial nature, an affidavit taken before a clerk or prosecuting attorney is not sufficient as a basis for the issuance of a warrant. JS. A warrant is regarded as insufficient and thus void if, on its face, it fails to state facts sufficient to constitute a crime. 3. Also, a designation or description of the offense should be written in the warrant, but need not be specified with the same technical straightness that is required in an indictment. 40. The rule on sufficiency of a charge on which a warrant can issue is stated as follows. the complaint or charge on which a warrant is issued must set forth the facts constituting the offense on the knowledge of the person making the complaint. And if be docs not know them, the witnesses must be examined who do know them, and no person can be arrested on the mere belief of the person making the complaint. Point 4. A warrant issued for a matter that is not a criminal offense is no justification for a constable who arrests upon it. A person. 36 Libreys vs. Harper, 89 flaw. 477, 104 so. 853, B55, 1925. Also see 5 am. Jure. 2D Aressel, Section 12, page 705. L7 Stalt. V. Pollock, 277 Minnesota 140. 48. Cannot be lawfully arrested by a sheriff acting under a copy of a court order or warrant in the form required. 42. Such copy is not valid.
Oh yeah.
Inaccuracies and imperfection do not vitiate a warrant which substantially charges an offense. But where a complaint, recited in substance in a warrant, is...
Now here's where I would respectively disagree, because I've already won things based on inaccuracies or imperfections, because these are violations. If it's not perfected, then it is something different. And if it's different, then it's not what it's supposed to be. So, I mean, you're not going to get away with like a period wrong or, something minor. But yeah, so I would disagree here, because if something is stated inaccurate or whatever, these are grounds for that. So, and this document is a little older, even though like I've done some of this before and after this document was put together. So yeah, minor things aren't going to, but yeah, there are certain things that if they're not accurate or perfected, will vitiate a warrant. So this part right here stands to be corrected, but let us go on.
Is verified merely on information and belief and does not state facts sufficient to constitute an offense, the warrant must be held to be invalid on JTS face. 43. Also, an affidavit that merely states belief in the guilt of the accused is insufficient to support a warrant of arrest. 44. The Supreme Court of Kansas said that a warrant cannot be issued which is verified on the county attorney's hearsay and belief. If a warrant, in the first instance, may issue upon mere hearsay or belief, then all the guards of the common law and of the Bill of Rights, to protect the liberty and property of the citizen against arbitrary power, are swept away. 45. An affidavit based upon a presumption or belief of crime does not give jurisdiction to the court to issue a warrant, and at common law, a constable or sheriff cannot execute a warrant outside their jurisdiction. 46. To summarize, the following are the basic requisites needed to make a warrant valid. A warrant is to be issued by a judicial officer and signed by him. It must state the facts that show the matter to be within the jurisdiction of the judicial officer issuing it. It cannot be based upon belief or suspicion, but upon probable cause. The warrant is to list a complaint which is to state the offense committed and the facts that constitute a crime. A warrant is to be supported by a signed affidavit made under oath by the person making the charge. It must truly name the person to be arrested, or describe him sufficiently to identify him. The warrant must also command that the defendant be arrested and brought before the nearest available magistrate. The officer is bound to know if under the law the warrant is defective, and not fair on its face, and he is liable as a trespasser, if it does not appear on its face to be a lawful warrant. His ignorance is no excuse. 47. The typical form of a warrant is like this. Municipal Court, Springfield Judicial District. To any peace officer of the realm of jurisdiction upon signed oath having been brought before me that the crime of larceny has been committed, and accusing John Smith of the same, you are hereby commanded forthwith to arrest and bring that person before me. Bail may be ad me head in the sum of $1,000. Dated, May 15, 1997, /S/Bill Wright, Presiding Judge. Every citizen should, when arrested, or at trial, request to see a warrant and check that it meets required criteria and object if it does not. Point out that the arrest is unlawful and how the warrant is defective. Such vigilance is necessary to secure liberty and to stop unlawful and oppressive measures from continuing in government. 49.
There you have it, guys. There you have it. That was a nice section. Had a good chunk of gem drops in there as well. That was the use of a warrant in arrest section. And we are going to be in a moment going into the next segment, which is bringing the arrested person before a magistrate. All right. Because there are some things that they have to do properly there. Matter of fact, all of it has to be perfected. And if it's not, which is probably what, like 80, 90 some percent of these arrests that have happened to all of us out there, were not done properly. And you can sue them for that. You can have your cases overturned for that. This information, you can use it in other areas and avenues of your life. Okay. I'm just giving you guys the pieces as a highly educated, non-belligerent, non-combatant, neutral party in this game. That's what a non-combatant, non-belligerent is. All right. I'm not employed. I am not occupied. I don't have an occupation. I am a private citizen in the private sector, just a national patriot. And anybody, any government, any system, any person, any state who's against the Constitution and is waging war, I highly suggest you see what the penalties are for such waging war against an American and the Constitution is treason. It's war. So careful who you wage war with, because my America don't stand for that kind of hooey. I'm gonna tell you right now, anybody that says contrary don't believe in every one of them. That's it, guys. For now, don't forget to hit that bell, like, subscribe. Like I said, we're gonna go into this next section, and that will be it for me in recording for this session. And I will finish up the next time. I think we're about 50 pages in at this point, and you got about another 25, and then we will do the master recording of all this information in one shot, and then we're going to keep going with other valuable information. So absorb as much of this as you can, use it as you see fit. With that being said, peace, and I appreciate you guys. Take care, stay healthy, eat good, eat better. Take your I was gonna say eat your vitamin or your vegetables, but most of them don't have enough daily nutritional value in them. So consult your doctor before doing anything. I know I personally take at least a multivitamin and other supplements. So I will challenge you with this. For those people, go and look up how many systems, type in on, whether it's Google or whatever else, I don't care which search engine you use, type in what are all of the benefits in the human body that magnesium provides. You'll find that there's over 300 different things that does to your body. And then you'll find out the average person is not getting anywhere near the daily recommended amount of that. Same thing with potassium. I think it's potassium chloride. Yeah. Look those up and you will be amazed. Sincerely. Trust me on this one. So, we are also going to be spending some time over on the Badwolf Media channel. I may keep that the same name, or I might rename it to Badwolf Unincorporated or Badwolf Unlimited, some of that nature, where we're going to be talking about some other stuff here and there. It's also the backup channel. So, and I've got like 4 or 5 or however many. So feel free to add any of those other channels as a backup, so that, you know, should the unthinkable occur, which already occurred literally when I first started this channel, but we negotiated a ceasefire, if you will. And but should anything like that occur, I have a number of other channels to be able to, you guys will be able to find me on there. In case SHTF, and that's stuff hitting the fan. Okay, it happens. All right. Other than that, don't forget to join the Telegram group. Information on that is on Black Site. A lot of people have been very successful in there. That's a spot where, if I'm too busy, there's people in there who have successfully gone through all of my material, won their court cases, done right to travel, won there, sued them, the states and police officers, and won. You can go in there and learn from them without having to talk to me if you guys want to do that. People are like, well, I wish I could talk to you every day, or I am in there sometimes. I do have admins who get along for the most part. And making sure everything is run properly. We do not take negative people in there. We do not take spam or BS or talking bad about me in there. We don't do we're not here for that. Okay. So you can join there. Beware of people pretending to be me hitting you up in the DMs or private messaging, offering you, money and um join their crypto, blah, 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 send them money. It's not me. It's not me. Anytime I talk to somebody, I talk in the open public. That's all there is to it. And if you reach out to me either through email or through that group or one of my other things, don't be mad if I don't respond to you. I get a lot of email. I I would have to have at least 12 people to go through all of them. So if I do respond, cool. I've seen it. Thank you. Thank you in advance for everybody who does message me. Um, Thank you for the supporting emails and just the very um, large amounts of people who are very positive about me and this information, and it's changed their lives, and they like how I convey the information and they vibe with me. So thank you in advance for that. And like I said, just support any kind of way you can. And if you can't, then just keep me in your prayers, positive energy and light. And that's about it. So I will talk to you guys later. Thank you for watching. I'm going to do this one more segment, like I said, and then I'm going to go get some food because I'm getting tired and hungry. Because I have to take my own advice and take care of me. That's all I got for right now. But all right, I'll talk to you guys later. Wolf's out.